Hello everyone, wherever you are. Welcome to my channel and thank you for your interest to watch this video. This is Contractual Capsules video series where I am providing topics about construction contracts to stakeholders in the construction domain worldwide and to support the profession by elaborating on some definitions for reducing the numbers of doubts, conflicts, and disputes among the involved parties. It is important to highlight that any content in this channel and this video represents the narrator's opinions and experiences with no liability or obligation regarding how, when, or where you use this content and for what purpose. Today's topic is Alternative Dispute Resolution Methods in Construction Business, or ADR. A dispute may arise when things go wrong between two or more contracted parties, and they start to see issues differently after a conflict or an incident where at least one party suffers damages and seeks remedies or a solution. It is important to know that not every conflict escalates into a dispute, but every dispute is certainly rooted in a conflict. When a conflict occurs, it is initially called a case, which can often be resolved before escalation. If no solution is reached, the case can be transferred to a dispute. The dispute resolution usually involves choosing the appropriate method, engaging the right qualified people, preparing historical records, presenting your case credibly, and tell your story seeking a favorable outcome, and try to win the game in a good faith. The party initiating a dispute is often called the claimant or plaintiff, while the other party is the respondent or defendant. The choice of the desired method depends on several factors, such as the current and potential future relationship between the disputed parties, their risk tolerance, how urgent is the case, the volume and complexity of incurred damages, applicable contract laws, and of course, the methods, costs versus your affordability. Here are the most common ADR methods in my opinion, presented in my recommended order of usage when a case turns to a dispute. 1. Adjudication. I like to call it the in-house dispute resolution approach, as it is ideally adopted during ongoing projects, where contracts must include specific clause outlining the adjudication process and how adjudicators are appointed. In this method, a Disputes Adjudication Board, known as DAB, or Disputes Avoidance Adjudication Board, known as DAAB, must be formed to provide an interim resolution, usually within 30 days of commencing a case assessment, to address the conflict timely and ensures the project's cash flow is not disrupted, particularly when dispute involves payments. The decision here is typically binding on disputed parties, until another disputes resolution method is pursued. In some countries, adjudication is proactively administered by local chamber of commerce to reduce litigations. However, the decisions made are not binding unless they are formalized through a settlement agreement. 2. Facilitation. If DAB or DAAB are ineffective or do not exist in the contract, facilitation can be a commercial option to use. Facilitation considers hiring a neutral third party, often called a facilitator, and typically is one person only, not an entity, who can be a subject matter expert or a trusted agent by both parties to assess the issue, lead informal discussions, and encourage negotiation between the parties. Facilitation can be conducted by phone call or email and sometimes via virtual or physical meetings. The facilitator starts by setting the ground rules of discussions, but is more flexible about discussions agenda and adopts a collaborative approach to encourage the disputed parties to express their views. The facilitator does not make decisions, but guides and helps parties to break the ice, negotiate, and reach their own solution. The decision here is not binding on disputed parties unless formalized through a settlement agreement. 3. Mediation. It involves appointing a neutral mediator who adopts a negotiative approach to meet with the parties and negotiate his and their views to jointly conclude a mutual satisfactory solution. Mediation is not binding unless the parties formalize the agreement through a settlement agreement. The mediation is usually strict about meeting agenda and structured discussions while maintaining confidentiality by a pre-signed agreement, which is often governed by local civil procedures laws. 4. Conciliation. It can involve one or more conciliators who are appointed by a legal authority as third party and is governed by the applicable Arbitration and Conciliation Acts. The parties are allowed here to present their story, but the conciliator proposes the solutions for the disputed parties to take it or leave it, where confidentiality is guaranteed by law. This method entails more formal process than facilitation and mediation, where the proposed solutions may be binding only if a settlement agreement is formalized. 5. Arbitration. I have seen during the last 2 decades that arbitration is generally approached by disputed parties only when the contract stipulates specifically that arbitration is a dispute method under the disputes clauses and terms. It is conducted in accordance with applicable arbitration rules and laws, and typically involves either a single neutral arbitrator or a 3-member tribunal. The single arbitrator is often chosen by the parties or by the designated arbitration center. However, the tribunal is slightly different, as each party selects 1 member, and the third is appointed either by the 2 selected members or by the arbitration center. Hearings are held to review the case before a binding decision is made, which is enforceable through local courts without a need for settlement agreement. Arbitration is more formal than the previously discussed approaches, but still less formal than the final method in today's video, the litigation. 6. Litigation. It is the final and the most formal and authoritative method among all approaches, because litigation occurs and is held in domestic courts and governed by local constitutional laws where a dispute arises. A judge or panel of judges makes a binding decision, regardless of prior settlements, unless a settlement is formally approved by and registered into the court. In conclusion, disputes are challenging and undesirable situations to happen between any 2 contracted parties. Please write to me if you want me to talk about creative approaches to try avoiding the disputes. We reached to the end of today's video. If you liked our content, kindly support us by like and subscribe to our channel and share it with your friends and colleagues to spread the benefit. Also, write a comment to us or send your query and I will respond too. You may also visit our website, concmaze.com, and search for and download our world's first mobile app, Concmaze, to access our construction contracts consultancies for free if you have a specific query. Thank you for watching. Goodbye.